Hi everyone, I'm Sheila Fisher. I'm a 3L and I'm on the board of the Animal Law Society. Welcome to Animal Law Week. It's our final day. We're really excited to have you here for this panel. So our discussion today is grounded in a recent case, Sullivan v. Washington, involving members of the University Institutional Animal Care and Use Committee, or IACUC, the bodies responsible for reviewing and approving animal research at research institutions. In Sullivan, several committee members argued that they should be allowed to serve anonymously, citing concerns about harassments and threats if their identities were disclosed. On the other side, advocates argued that transparency, including knowing who is making these decisions, is essential for accountability and public oversight of animal research. And that dispute raises a broader and increasingly relevant constitutional question: when someone exercises public or quasi-public authority, do they have a right to anonymity? To help us explore this question, we have three incredible panelists. Professor Noah Feldman is the Arthur Kingsley Porter University Professor at Harvard. He specializes in constitutional studies with particular emphasis on power and ethics, design of innovative governance solutions, law and religion, and the history of legal ideas. Asher Smith is the General Counsel for Litigation at the PETA Foundation. He handles cases related to the Endangered Species Act, constitutional issues, and false advertising in animal product marketing. Smith has achieved victories against Tiger King figures, research universities, and major food brands. Before joining PETA in 2018, Asher attended Yale Law School and then worked on securities litigation and the fight for marriage equality. Julia Allison is a fellow at Harvard's Shorenstein Center, focusing on the interplay of social, independent, and legacy media, technology, culture, and social impact. She holds a master's degree from Harvard Kennedy School and a bachelor's from Georgetown University. If you'll all just join me in welcoming our panelists and vision. So to begin, we'll start Asher. Could you briefly explain Sullivan v. Washington, what the dispute is, and why this issue matters in the context of animal research oversight?
Sure. So maybe I'll just start with, why do we want transparency into these laboratories? And I think it would help to explain a little bit about what PETA is looking into with respect to these laboratories and what's actually going on. So when PETA investigates what's going on in laboratories, this tends not to be the kind of animal experimentation that I think the public mostly assumes is what's going on. Experiments that you're legally required to do to bring drugs to market. What we're talking about here are what PETA terms curiosity-driven experiments. Experiments that, as far as animal advocates are concerned, tend to do little more than help these universities churn grant money. One example that's always close to mind for me, we litigated a public records case against Oregon Health and Sciences University over videos of experiments on prairie voles, where in order to supposedly study monogamy in humans and what effect alcohol has on that, they took prairie voles, a notoriously monogamous species, and pumped them full of 15 bottles of wine a day, the equivalent, and watched what would happen if they released them in shoebox-sized crates. Would they mate? Would they fight? Who knows? But somehow this is important to science for some reason. A similar experiment at Harvard that I'm sure folks here are somewhat familiar with, experiments where baby primates literally had their eyelids sutured closed so that experimenters could discern what happens to their visual development, behavioral development, supposedly in order to draw some kind of conclusions about autistic human children who aren't used to who tend not to look people in the eye. This is all extremely attenuated stuff, but it's the kind of stuff that goes on all the time and is horrifically violent. Sometimes you have animals getting eyelids sutured. Anytime you're studying what happens in the brain, that tends to mean intensive repeated brain surgeries. And so these experiments tend to end with all of the animals involved being killed. So how do these experiments happen? Well, every experiment has to be approved by an IACUC. Every institution that does experiments has to have an IACUC. The IACUC's only job is ensuring compliance with federal animal welfare laws. That's the Animal Welfare Act, and policies created by the National Institutes of Health, Nigeria, and other. Now, I'm sure animal advocates have some skepticism about the efficacy of these laws, how far they reach. But I'll plug them for a second, which is that if you took these laws seriously and you had an IACUC that was interested in enforcing them to their full extent, they might be transformational. For one, it would impose some limits on the number of repeated invasive surgery you can do on these animals. Also, you should, and the law says you should be doing this, require experiments to really justify what they're doing and whether there's any less violent, less invasive alternatives to what they're doing. So why do these experiments still happen? Well, PETA was focused especially on the University of Washington because they had a notoriously bad animal welfare record and wanted to know, why are they so bad at their job? They've been called out in federal inspection reports. There have been numerous instances where animals have died from neglect, not only during the course of experiments, but things like being left to die of thirst and hunger. There are animals who choked on their own vomit. And whenever these instances happen, the IACUC doesn't seem particularly interested in doing all that much about them. Very frequently, it leads to no repercussion for laboratory personnel who might say have left animals to literally die of thirst through neglect. So PETA looked into this, and one of its conclusions was that this IACUC seemed to suffer from a great degree of industry capture. Under the law, IACUCs are supposed to include a sufficient number of non-biased personnel, people who represent the community, who don't have linked to the university, who don't come from the animal experimentation world. It turned out that did not seem to be the case, at least historically, at the University of Washington. PETA had identified folks on the IACUC serving in those kinds of roles who actually are from animal experimentation lobby groups, who are former employees of the University of Washington, who have been animal experimenters. So in order to nail down this conclusion, PETA sought out the membership of the IACUC. Who actually is on this committee? Well, one way you could find out would be to go to an IACUC meeting. That doesn't work. They use names and numbers to identify themselves rather than their actual names. You could submit a public records request for a membership roster. No dice there. They don't keep a roster as a permanent public record. They just overwrite it. So they say there's no document produced to you. Finally, PETA hit upon, we can ask for your appointment letters that go out to all the members serving and specify their role. That worked, but then before receiving the letters, PETA actually learned that, in fact, the members of the IACUC had sued the university in an attempt to enjoin their release. And in that lawsuit, what they claim is, we're beset by threats. People are calling us Nazis. So this raises a serious First Amendment problem that justifies anonymity. Now, my colleagues here, I'm sure will be able to explain the legal doctrine involved in those claims. This case evolved a lot. It went through up to the Ninth Circuit 3 different times. It involved a First Amendment right to anonymity, a 14th Amendment claim for bodily integrity, a claim for a privacy interest. And at each step, though, they justified this based on what PETA saw as basically valid criticisms of them. When we actually went to the record and to build our argument that these are not examples that could give rise to any kind of protected constitutional interest, even aside from the fact these are all government officials, what we found is that none of their stories held up. They said, people call us Nazis. Well, PETA went to the video of that meeting. It turned out it was an elderly retired UW professor who was repeating a famous aphorism by a refugee of Nazi Europe, to the extent that to animals, all humans are Nazis. Every institution that treats them this way is an eternal troubler. So that's not exactly being violently accused of Nazism. That's actually exactly how you'd imagine public comment at public meetings going. We challenge that. They come back. The chair of the IACUC, Dr. Sullivan, well, they threatened my cats. someone stood up at a meeting, used the name of my cat to intimidate me. I asked the same professor, were you there? What happened? It turned out that was him too. She had told him the name of her cat and they were chatting before the meeting. That's how this case tended to go. We eventually win the case at the district court phase after our third Ninth Circuit win, after unearthing a document where the chair of the IACUC admitted a new incident is the first time I've been scared a little bit, which is not what they had claimed in their lawsuit. But before we get to that point, we had a lot of legal argumentation around just who's allowed to claim this kind of anonymity.
So Professor Feldman, stepping back from the specifics of the case, how should we think about this issue doctrinally? The First Amendment protects anonymous speech, but by serving in a governmental or quasi-governmental role, are you giving up some of these traditional First Amendment protections?
Thanks, Shira, and thanks, everybody. One of the great things about being a professor of constitutional law is I get to talk about the issue without reference to the particularities or the policies that are in play. So let me just note a few things. The first is that it's interesting that this case involves a state institution, and that the way, if I'm correct, Asher, that you were able to lodge your arguments for transparency was based on public records laws, which were state public records laws.
Exactly.
Okay. So the handful of you who've been in my First Amendment class know that this is kind of like a point that I make a lot, because there's a lot of doctrine about public universities and free speech in those universities, because the law, the constitutional law, recognizes a university that is public as a state actor. That is a weird, anomalous doctrine, and I'm just pausing to notice it. Because if you think about it, public universities do effectively the same job as private universities, but they're subject to the First Amendment, and they're also, in this instance, subject to specific state laws, like public records laws. The public records law could be amended. So if the state of Washington wanted to make sure that you didn't win your case, the legislature could pass a law exempting the state university, or even this particular committee of the state university, from its public records requirements. So on the transparency side here is a statutory argument that's specific to public institutions. Then on the other side, the First Amendment claim, interestingly, was substantially weakened for the university party because they work for the university. And if you work for the government, your participation in action on behalf of the government is typically, I'm oversimplifying this, but thought of as the exercise of public employment in which your free speech rights, and so by extension, your anonymous free speech rights, are reduced. So what that means in practice is if you just imagine that this case took place against a private university, let's say it were a suit against Harvard University, there would have been no public records requirement requiring that Harvard disclose the membership of the committee. And even if there had been such a statute saying that Harvard had to disclose that, the employees could have made an argument that as private citizens, they were entitled to speak anonymously, and that not being able to speak anonymously would limit their free speech rights. They might not have won on that because there's a question of whether they were speaking, whether they were just doing their jobs, and there would have still been, Asher still would have been able to make an argument about that. But the case would have looked really different. So that's kind of an interesting feature here. The upshot is that we get a case that really interestingly poses a conflict between transparency and public actor, between the transparency of government activity and the asserted interest of government employees, because that's what the state university employees are under the law, to avoid being subject to public criticism. And in that framing, I think it makes a lot of sense that Asher won the case, quite apart from at the constitutional level. So that's sort of that's a framing of the legal issues here, noting that there's some weirdness by virtue of the fact that the whole case would have come out, I think, very differently had been a private university.
Very interesting. Julia, how important is knowing the identity of decision makers for effective advocacy, particularly in areas like animal welfare issues where public pressure is kind of the only thing that's holding people accountable?
So first of all, I just want to name my priors. I am an animal rights advocate, a pretty outspoken one, at least at the dinner table. Noah is also my husband, and I do lecture him on a weekly basis, usually about animal rights. I became an animal rights advocate at 19 when I saw videos of what was happening in factory farms, and it was a very instantaneous decision for me. So I just want to name that first. I am not unbiased here. So I think to your question, why is it important for us to have transparency when we have actors that have decision-making power, especially over groups that cannot consent? So that would be not just animals, but also children and other groups that just don't have those same rights. I think it's critical to have transparency. And I'm also coming from a perspective of, as a media expert, where I myself have been a public person who has experienced online harassment, doxing, a lot of the misogyny that is rampant on the internet. I have experienced that myself. So I'm not immune to feeling that it's inappropriate to harass people, but I think that there's a really critical distinction that we need to think about, which is in the case of actors that have this control over these parties without the ability to defend themselves. The reason it's important to have transparency is that we don't have a functioning democracy or society without that transparency. And if we need to mitigate harassment, and I think actually, Asher, you made some good points that the harassment they were claiming doesn't actually seem like it was harassment at all, so that's really important. But of course, we know that there is real harassment out there. That needs to be handled in an entirely different way. It doesn't mean that we need to allow for anonymity when there ought not to be anonymity. One of the things I'm thinking about, even besides animal cases, which I think are really important, you look at the ag-gag laws. I mean, this is obviously about companies that are attempting to use anonymity to protect abuse. That's not appropriate in any way, in my personal opinion. But you also look at like what ICE is doing, right? And their anonymity is protecting abuse. So I think the big question we need to ask is this anonymity protecting abuse? Or is this anonymity, like in the case of whistleblowers, in the case of people reporting abuses, is it critical to have that kind of anonymity such that abuses can be put into the public eye? So you just want to look at the power differential, right? Who has more power in any given case? And that's the litmus test, in my opinion, if that makes sense.
Absolutely, thank you. And that brings up a great point. Beyond the context of these IACUCs, there are other potentially controversial roles where individuals have significant authority and power, as Julia was just saying, like institutional review boards approving human research, federal grant peer review groups at the NIH, or even ICE agents. And they could try to claim similar anonymity protections. So how might these other roles be implicated by this, these new arguments? And Asher, if you also want to share what your plans, if you're able to, about what PETA plans to do about bringing this possibly nationwide or expanding this.
Sure thing, yeah. And this is an area of law that keeps developing. There's actually a really interesting decision about a week ago in the Southern District of New York about deposition videos online of personnel with Doge and whether or not the court can get a protective order against that dissemination. And there the court saw this as very straightforward. Your public officials doing your public duty, no Rule 26 protective order. And what helps make that so important is that keep in mind that the backdrop of this case and cases like this are PETA's First Amendment right to petition the government. PETA wants to enact change. One of the ways you enact change, obviously, is peer opposition, but also if you have good faith criticisms, ideally, you could just bring that to the government officials, tell them what's going wrong, and hopefully they'll do something about it. And there it makes a big difference whether or not or to know whether the people on these boards are operating in good faith, whether there are members of the boards who come from different perspectives, or whether, as we found out in discovery in this case, before the fourth litigation of a preliminary injunction, that actually in their private communications, they refer to animal advocates all as extremists. Or as we found out in that Oregon Health and Sciences University case, that actually their university law enforcement was illegally tracking animal advocates. So knowing information like that becomes critical. And here a next step, because PETA was finally able to get that information after the lawsuit. Remember, this is a case brought by the IACUC members, so it doesn't end in a court order for PETA. We have to threaten additional litigation under public records law, under open meetings law. But we finally get all the records. They end the practice of anonymity at their meetings. We know who's been on this committee during the full historical period now. So PETA has written to the federal government explaining why PETA feels this IACUC has not been legally constituted and pushing the federal government to take action, perhaps in the form of clawing back grant money or other penalties. And that would be revolutionary if that happened, if it actually came to be that there are real consequences for stacking the deck and letting your IACUC become a complete tool of the experimentation industry.
Do you guys have any other comments about the other contexts where this could apply?
You made the point about, Julia, you made the point about ICE, and I think that's obviously very much on everybody's mind now, and it's appropriate. But you also made another point that I just want to emphasize, which is that the threat of harassment in the current universe in which we live is genuine and real and pervasive. And there are a whole range of social functions that we probably, each of us in this room would agree are really important to have performed. And people will refuse to participate in those social functions if they know that they're going to be subject to harassment. And that harassment is increasingly online harassment, but since the distinction between being online and being in real life is, even to make that distinction makes you sound like you're as old as I am. I mean, there really isn't such a distinction to a very great degree. The dangers culturally and democratically of online harassment continuing the way that it is are very, very, very substantial. And, you know, I think an example would actually be if there were broader exposure to people who served on these committees, and if there was a targeted campaign of online, let's say, First Amendment protected under current law, harassment of people in those committees, what'll happen is that no one will agree to serve on those committees. And maybe the consequence would be better for reducing bad kinds of experimentation, but also maybe it would go the other way. You know, maybe Congress would then step in and change the law and say, well, we need to have experimentation, so we're not going to make the same requirements of the committees, right? I mean, there's different ways that this can go across the board. And so, you know, I think even in the ICE context, where it's, at least to me, intuitively, it seems clear that having, you know, armed officers, in many cases violating people's rights, with no individualized recourse is obviously wrong in a democracy. I think it's important still, at the same time as asserting that, and I've been saying it a lot, you know, over the last year or so, to remember that public employees still do need to be protected from various forms of doxing and harassment. So in general, my view is, and I think this is what I heard you to be saying, we should actively require transparency, but we should also have laws that actively protect public employees from public harassment. And we should do better at the latter in order to make sure that we keep transparency. Otherwise, we're going to lose transparency.
Yeah, so I agree. I want to paint two pictures. I want to paint the picture of a woman running for office where there is significant risk of harassment at levels that we already know about now, but then you add in AI deepfakes, and I believe that there is a serious chilling effect. Why would you run for office if this is the potential harassment? So that's like one use case of, okay, we want to make sure that we do not have the ability to dox and harass women running for public office, one case. But then you have this case of people not just on committees serving to look at experiments, but also people running factory farms, people in ICE, potentially abusing people, I think definitely abusing people. And should they be protected with anonymity in that particular case? I agree, obviously, that we should not be able to dox or harass people. But I think that we need to look at platform solutions for that. We need to look at Section 230 and maybe repeal that. We need to look at all of the ways that the social media platforms allow for that kind of harassment and not say, okay, well, now we're just going to throw out the concept of transparency. I think if we're looking at, for example, are people going to be on these committees if they think they're going to be harassed? I'm not persuaded that that's a strong enough argument for anonymity for these particular communities. I think we need to look at this from the perspective of society and say, okay, we are utilizing an 18th century framework for 21st century problems, and that's not even talking about AI deepfakes. Okay, like that's just talking about what is available right now if you want to harass someone on social media. But I also have a lot of compassion for being in a situation where you're trying to come up with solutions to get people to pay attention to the abuses that are happening right now with animals. So I have a lot of compassion for PETA, even though people are like, well, it's extremist. Yeah, well, and so is the harm. So I think we're walking a very fine line, and I think that the question really is, can we separate what is harassment from what is holding people accountable? Genuinely accountable. And I think that's what you're pointing to, Asher.
Yeah, I think that's right. And I think what this series of cases really illustrates is the need for precision as well, because you could imagine this case coming out another way and then chilling a lot of valuable advocacy and speech. After we debunked a lot of their examples in the last iteration of the case, their factual presentation included basically any high-profile experimenter from around the country who'd received mean emails. That was an example they had in their papers. And our argument in response to that was twofold, and the court mentioned both of these in going our way on the motion for a preliminary injunction, which was our argument that, one, you have to understand these people who are experimenting on animals are receiving this feedback not only because of what the experiments are, but because they are public employees putting themselves forward as faces of this experimentation. They are the ones who run their laboratories. They are the ones getting this grant money that is going to fund their specific work. So they are very much public actors and putting themselves forward. But then also, what category are we actually talking about? Because they try to advance the argument that there's a constitutional protected privacy interest in IACUC membership. But these aren't IACUC members. These are just people involved in the animal industry more broadly. So what would happen if you crafted a constitutional rule that allowed protection just because people in a related field, even a closely related field, might experience some kind of alleged harassment? So we definitely pushed the court to recognize, excuse me, this is a case about IACUC membership. There are no examples put forward about what happens to people because of their IACUC service. In practice, actually the opposite. We pointed to numerous examples of IACUC members of this IACUC even, bragging about their membership, using it as a credential to burnish their reputations. It can't be that you can just pluck examples from anywhere.
Can I just one quick sentence on that? I know a case that was very much implicated here, and you and I were talking about this morning, is NAACP against Alabama, which is the first case in which the Supreme Court recognized a right to anonymous association. It's also where the court invented the idea of expressive association. And there, the state's position was, the state of Alabama's position was, this is a public records law. It's a private organization, but we have a requirement that if you are a corporation registered to operate in the state, your members have to be made public. And the state said, we're not going to harass anybody. This was Alabama in the 1950s. But everyone else was going to harass the people. So, and I take it that you recognize that there's circumstances where the anonymity of private actors is actually justifiably constitutionally protectable. But there's a debate, as you say, about what the case is.
As a lawyer for a nonprofit organization, there are definitely tons of times when we hug NAACP v. Alabama real close.
If someone wanted, in the state of Washington wanted to make you disclose PETA members, you would cite NAACP against Alabama.
Right.
Yeah, and you'd win.
Okay, so given this kind of conflicting situation, how do you guys think that courts should draw this line? Should it be a different rule for different types of bodies and differ if it's like an advisory body or a regulatory or legislative actor? How should this be decided?
I'll just plant my flag. I think that SDNY in that decision from about a week ago got it dead on accurate. If you're doing public work as a public official, full stop, you just can't have a right to anonymity. That seems like a very clear, obvious, bright line to me.
Yeah, I mean, I agree with that. I was going to say the NAACP versus Alabama. I was going to cite that case, although it's I think the relevant part of that case is that we have a group that could potentially be described as one with a lot less power in a situation where they would be threatened, physically. And I want to make a distinction between a mean email, which I've received many of them, and being physically hurt or doxed in a way that would endanger your work. And so I think that's a really critical distinction there.
My only variation on that is I do, in general, agree that public officials doing public, I guess I'd put it, I think I would draw the line a little differently. I think that certainly elected officials and public officials who are engaged in activity which is a matter of legitimate public concern should not have a First Amendment right to be exempt from public records laws. But I do think that there are plenty of people who work in the government who shouldn't automatically be subject to having their identities disclosed just because they work for the government. There's a lot of people who work for the government in all kinds of functions, and it could be risky for some of them to, or just undesirable in some cases. Imagine, your postal worker, or your trash collectors. It's not obvious to me that there's a general principle that what they do because they're employed by the government should subject them to a lack of anonymity. And honestly, when it comes to universities, for the reason I mentioned earlier, I work in a university, it happens to be a private university, but I have a lot of colleagues who work in public universities. They do the exact same job that I do. And the idea that because they work in a public university, they should have no privacy interests, as a general principle, to me, goes too far. I think you have to look at the specifics of what the function is. So I'm very sympathetic to the argument that if your job is to apply a federal statute, under particular circumstances on a matter of public concern, you shouldn't have an anonymity right. But I don't know, if you're a teaching fellow, teaching a seminar, is it totally, or as a, if you're janitorial staff in a public university, it's not obvious to me that everyone has a right to know exactly who you are. And if they know who you are, they know where you live.
Well, isn't it just about who has power over another? I feel like that's really the key element here. If you are in a public capacity where you have power over others, where you are making decisions on behalf of others, that's where the right to anonymity feels like it doesn't make sense to me.
Yeah, I think it really is a functional test, to steal Professor Feldman's language. Coming back to that initial First Amendment argument about freedom of association, the precedent that the plaintiff Iacocca members were drawing from was a Ninth Circuit case about fetal tissue researchers. And that was a case about their elective research interests that they had a lot of personal choice over, even though there were aspects that overlapped with their government work. There was a big functional difference between that and someone actually serving in their government role, only doing their government function. And the Ninth Circuit found it compelling in that iteration of the case, the legal arguments we put forward explaining that, well, service on an Iacocca only involves implementing federal law. They are not actually reaching into the experiments themselves to suggest or dictate anything about the methodology, the decision to do it. They really do have this legally prescribed role, and there is just not a personal function to it.
And on the power, I like that as a general ethical matter, but it's very hard to do in practice, right? So let's say we're a public university, and I have a teaching assistant who's helping me with one of my courses, right? And seen from the standpoint of the students, let's imagine the teaching assistant, the teaching fellow is doing the grading, and the person has power. But seen from the perspective of relative to me as the professor in the class, maybe the person doesn't have power. So, it's not so simple to say, would that person then be subject to a disclosure requirement? I just think the real world cases are make that hard to apply. But I agree with that at an ethical level, but I think it's very hard to apply it in practice.
Well, thank you guys so much. I want to save some time for audience questions because we have a very engaged audience today. So we have about 15 minutes. If people have questions, want to raise their hands. Professor Stilt.
But the question would be then, for all of you, and Asher in particular, so now what? What's the payout? What's the value to PETA now of being able to identify the IACUC members? And I'm not, of course, you can't disclose your strategy, but just in general, what might an advocacy organization do with that information? Would it be, well, I can imagine, but I would love to hear you, but also Professor Feldman and Julia as well. Like, what might one do, and does that raise any of the concerns that were presented in the case, which I agree was also rightly decided?
Sure. And as a strategic impact litigator, this case was a bit of a strange one in that it was really for us defensive litigation against a strategic impact effort by our adversaries. They are the ones who initiated this case. They were the ones who wanted the result to be a precedent for them that this information is not subject to disclosure, that they would definitely have cited by every public research institution around the country to prevent this kind of disclosure. So goal number one, preventing that kind of precedent from existing. Having done that, then using this as a tool to, one, get more transparency, to be able to cite the information we have about industry capture, to buttress our arguments about the public interest at stake, and also to use it to draw attention to what is actually happening in these laboratories, why and how. As I alluded to early on, it's PETA's view that a very major factor for how a lot of these experiments are able to happen and how animals are allowed to be treated in this way without repercussion has to do with exactly who is on these oversight bodies. And by providing public education about how these institutions work, well, hopefully that changes minds about, one, whether these institutions should exist. PETA has a long-standing campaign arguing that actually the remaining national primary research centers shouldn't exist. They're doing antiquated work, they're holding science back, and they have horrible animal welfare records. To say nothing of our ability to then use this information in other contexts to find out about who serves on other IACUCs, which have and still are resulting in their own public records fights in other jurisdictions. And as we see in this case, like I alluded to earlier, be able to argue to federal regulators that, hey, there is a major composition problem here. We kind of need a federal regulatory precedent that states, okay, this is too far beyond the line of who's supposed to be on these committees.
I'll just add that I think it's really important for investigative journalism to be able to have this kind of transparency. And I can't obviously speak to what PETA's goals are, although, Asher, that was fantastic. But I think when we have anonymity in any of these, whether it's animal experimentation or factory farms or really anything like that, it has a chilling effect on the ability for the media to go out and cover the incentive structures. So I think, Asher, if I'm understanding what you're saying, the ability to understand who each of these people are, where are they getting their money? Are they getting paid by interests that are potentially pushing them in a direction that might be unethical? That's really important information for the media to have. And if we have, a lot of statutes that are occluding that, I think that that's problematic in general for the media.
Yeah, I couldn't agree more. And in litigating these cases, keeping those repercussions in mind is so important, because when we got our very first decision at the district court level, one of the next steps was going to all these other potential stakeholders who might not have realized themselves to be stakeholders and telling them, this just happened, this is going to be going on at the Ninth Circuit, don't you want to get involved? And I think it made a big difference at the Ninth Circuit that we had an amicus filing on our behalf from the Reporters Committee for Freedom of the Press, representing a coalition of media organizations that included the Seattle Times. And at the final stage of the case, the district judge actually mentioned that, newspaper reporters have also submitted public records requests for this kind of information. This is inherently newsworthy. That is important to the balance of equities here.
Great. Yeah, back there.
Thank you. First of all, this has just been so interesting. I wanted to pick up on the thread a little bit about NAACP, because just stated very broadly, the associational right has been incredibly important for the protection of minorities, for academic freedom, for the advancement of science, and so forth. And I think I agree with the substantive outcome in this case, but I was imagining a hypothetical, for example, or it's actually not hypothetical, this happens in the real world. There are research boards, for example, that approve funding for very politically controversial but deeply important research about, say, for example, gender issues or things like that. In that instance, it seems to me that the decision makers in those cases, their anonymity could be incredibly important, because we know in real life they are in fact harassed a great deal. And so I was thinking about how one might distinguish these two cases, by what principle.
I think that's the right question, Ella. I think it's not so easy to distinguish it. Even if you're talking about the consent model, you mentioned children as subject to non-consent. So imagine it's a curricular body deciding on high school and elementary school curricula, which have been deeply politicized. And under those circumstances, the kids have to go to school. And there are some mild free exercise exemptions that are emerging just in the last year. But for the most part, you're mandatorily subject to the curriculum. So you don't have, the full idea of independence. And I think one way to answer that question would just be to kind of bite the bullet and say that decision-making body also has to have its membership disclosed, but we need to have more robust protections against the kinds of harassment that people are subject to. I think that would be like one way to get at it. And I do think that the hard problem that kind of underlies this whole debate and the direction that the case took, the reason that the parties that you were litigating against were asserting constitutional rights, is that we do live in a world where our existing First Amendment norms and our background rules have enabled people to be subject to extreme harassment and not be able to do much about it. And often that harassment, as you've taught me, takes the form of harassment by anonymous people who take advantage of their First Amendment anonymity rights to harass other people. And then there's literally nothing you can do about it. It's an extreme and very common situation if you're being harassed anonymously. And so, if there's no method that we adopt to constrain harassment, what's inevitably going to happen is we're going to get a pulling back on transparency rules. You see this on the Supreme Court, where the justices individually are increasingly less sympathetic to free speech protection for critics of public officials, because they are public officials and they have been subject to extreme forms of criticism and sometimes even of harassment, and they have U.S. Marshals to protect them, unlike most federal judges and unlike almost all state and other public employees. So I think it's a real structural problem that needs to be addressed from the side of anti-harassment, or we're going to lose transparency.
I just want to say one quick thing on that. At the very highest meta level, we're talking about abuse. of all kinds, right? Like that's where this kind of comes all the way around. And I think as a society, both legally but also, culturally, we need to make decisions about abuse, whether it's harassment or whether it's abusing animals or whether it's abusing children or whether it's abusing women or anyone else. If we are, and I think we often are like, well, what can we do? It's harassment, or is it like, it's like we can't really say it. No, we need to start drawing a line in the sand and saying this is not acceptable, and we need to either legislate or we need to have other kinds of protections built into the platforms, built into the way that we utilize our technology. And unless we do that, there will be a chilling effect overarchingly. But that fear of harassment should never actually stop us from saying, you cannot abuse an animal, you cannot abuse a child. So it's if we just focus on what is abuse and how can we stop abuse of all kinds, I think we're moving in the right direction.
And it's also just a background fact here that the First Amendment is just very capacious in a way that, from a comparative law standpoint, is very unique, because there is a First Amendment boundary here. That boundary, though, is true threats. And if you're not talking about harassment that amounts to true threats, it's going to be very hard to get an injunction that stands up on appeal against that. Obviously, here in our case, what we saw was a gambit of trying to say being called a Nazi, had that actually held up, had it been, really virulent accusations of Nazi-like behaviors, that should be considered akin to a threat, because obviously people have really set views about what they think about Nazis and what should happen to them. I think for the best, that was not the decision here. Actually, while this case was pending, there was a case in Massachusetts State Court that stood, again, for the principle that at public meetings, you can't bar people from calling public officials Nazis. You are allowed to do that. To not give short shrift to the plaintiffs in this case and their efforts to frame this narrative, like we were talking about, they tried to present this as a case about harassment of public officials that they thought judges would be very sensitive to. So when they launched the case, they frame it entirely around the specter of home harassment, that releasing this information will allow protests at these officials' homes. And that's so interesting, because I can see how that's designed to be a hot button for judges. And something that we did that I think was very important was reorient the case around the issue of, well, no, PETA's interest is not necessarily doing these home protests. It's finding out who actually is in these positions that have strict eligibility criteria. That's the goal here. But I also do want to plug the fact that you are constitutionally allowed to protest in front of people's homes.
Can I just say, the First Amendment's not quite as extreme as you just depicted as being, Asher. I mean, every municipality and state in the country has laws that prohibit coming up to a person and harassing them on the street. And it's not the case under existing doctrine that those either face strict scrutiny or would only be constitutional if they constituted true threats. But we're not there yet. So there's actually more, and this is the reason I'm saying that is not just to be pedantic, but it matters. When I say that we can have legal restrictions on harassment, I'm not saying that we need to weaken the First Amendment as it presently exists to do so. Because I'm strongly in favor of keeping the First Amendment, where it is. But what I'm saying is, under existing doctrine, there is room to outlaw harassment of all kinds, and it is in fact outlawed in, again, every jurisdiction in the United States.
Right, and I would just say, what kind of harassment are we talking about? Is it something that can be characterized as harassment, or are we talking about very unpleasant but still protected speech?
Thank you.
Any other questions? Wow. Wow. Oh, perfect.
I just might not be understanding the ruling in Washington here, but is there any showing that the plaintiffs could have made in terms of threats of harassment they were facing that could have prevented this, or is the rule a categorical one that in this like public state university context, people on these kinds of decision-making boards can't assert this right to remain anonymous?
So we had two different kinds of arguments, one the purely legal, two the factual. On a purely legal level, we did convince the court on the First Amendment issue that this is a category error. An IACUC member is not involved in that capacity in anything that would implicate a freedom of association right. Hence why later on in the case, this comes under privacy law principles. But we also are making the point that even if you disagreed with a very technical legal argument about the role of an IACUC that involves reference to the IACUC regulations, the provisions of the Animal Welfare Act, that what they're alleging happened to them and what they credibly fear still would not be sufficient. You could imagine a world where both there is a different understanding of those IACUC regulations, or the court saw the history of privacy protections for IACUC members that became important later differently. And if that was the case, well, then we're having an argument about whether or not their factual parade of horribles is sufficient.
Didn't they try to claim that the animal advocates were going to come and attack their pets? That was what they were also.
We did see that claim, yes. And that was fascinating because that was cited in the initial TRO order in this case and preliminary injunction order that we ended up appealing successfully the first time around, where they had an affidavit that said, I've heard of people involved in animal experimentation. I heard that someone had their dog kidnapped, which again, we argued, well, that's just not anything. You can't premise a constitutional holding on this kind of hearsay within hearsay. But then also we looked into it and obviously can find no example of this happening. And actually at the later stages of the case, the anonymous affidavit submitter actually did withdraw that claim. And that was important because as lurid and strange as that sounds, that was actually the thing they cited that came closest to being physical harassment, physical violence, not just harsh speech.
You can see at the structural level that what's going on at the highest level is that people in general are afraid of the consequences of having their identities made public, and that's a product of changed norms. And I would argue that it's really a product of social media harassment, which is very, very difficult to block legally. The state harassment laws that I was describing to you are almost all restricted to in-person interactions. They're designed to avoid the situation, to criminalize the situation where someone just comes up to you on the street and addresses you in abusive language, which under most, as long as it's directed at you, and if there's sufficiently a pattern that arises to the level of interpersonal harassment, that's still criminalizable and not free speech protected. But say the identical words and say them online, and the doctrine increasingly does treat those as First Amendment protected. And so even though the allegation here was, as you say, speculative and was about a pet, it's reflective of a deeper problem, I think, that we just have to acknowledge. This goes back to what you were saying, Julia, about contemporary, 21st century problems and the necessity of evolving the doctrine to make some sense of how it feels to be subject to online harassment, which maybe doesn't feel exactly the same as being subject to interpersonal harassment in person, but it's continuous with, and it's a lot more prevalent.
Awesome. Well, we're going to have Professor Still just give a little thank you, but if everyone wants to just quickly clap for our panelists to thank them.
Thank you. Thank you. That was an amazing way to end what was already an amazing week. And I just have the quick and pleasurable job of thanking everyone who brought this week into being. So the Harvard Animal Law Society President Valerie McCarthy, who's over here, and Animal Law Society member Akbar, who I think is still here. There you go. Akbar has been brilliantly moderating the sessions. One of the sessions that began the week, invaluable to the smooth running. See, he's already up there trying to troubleshoot anything that might happen. And Valerie's leadership has made this week truly inspired and seamless. And the entire Animal Law Society, thank you all for everything you did to bring these 5 amazing panels together. I also want to thank visiting Professor Mary Hollingsworth, faculty director of our Animal Law and Policy Clinic, who was instrumental in making the week a success as well. She contributed ideas, guidance, and has been on the ground encouraging and helping the students all the way along. And our Animal Law and Policy Program Executive Director, Lana Nadge, right here, and Associate Director of Ethics, Culture, and Religion, Bonnie Nadzem, who's online, have supported the students and have made this week come into being as well, dealing with everything from flights to microphones to bigger substantive issues to make it all happen. And then all the moderators. All of our moderators are students, and that's extremely important to us. Even taking this role right here, I feel uncomfortable because this is a student production. We're here to support you. But one must thank the students, and so rather than make you thank yourself, I want to thank you as moderators who showed deep engagement with the subjects, presented amazing questions, adjusted as the questions were answered. And so that's Akbar again and Valerie, Varun Iyer, who's here in the back, Andrew Chiachi, and Shira, of course, from today's panel. And then the Harvard Law School events team who helped us get rooms, which is real estate is one of the biggest challenges in the school. Kara O'Neill, and then from the IT services, Charlie Medeiros, Allison Kellner, Osvaldo Panagua, and Ben Galcheran. So everyone, thank you so much. I believe all of these have been recorded and will be online, so you can share with your friends. You can, we'll let Julia do all the media promotion, the social media promotion of these events. But thanks everyone for making the world a more humane place.